In Section 1, you will learn about key concepts, unwelcome behaviors, sexual harassment, quid pro quo, and hostile work environments. In recent years, the topic of harassment in the workplace has been brought into the national spotlight, bringing with it renewed awareness about the serious and unacceptable nature of these actions and the severe consequences that follow. This course was designed to meet the requirements of AB 1825, as well as the mandates outlined in California, AB 2053 on abusive conduct, and California, SB 396 on gender identity, gender expression, and sexual orientation. The term harassment may mean different things to different people, depending on your life experience. Certain conduct may seem acceptable or have seemed acceptable in the past. That does not mean it is acceptable to the people we work with. The purpose of this training is to set forth a common understanding about what is and what is not acceptable in our workplace. By the end of this course, you will be able to identify a workplace behavior that might be considered harassment. Explain the legal and other consequences of harassment. Describe your role and responsibility in creating a work environment free from harassment. Describe sound policies and procedures on harassment.
Unwelcome behavior is a major component of sexual harassment. It creates a hostile work environment. It is behavior that is uninvited, unacceptable, and offensive in the eyes of the other person. It is important to think carefully about how others may react. As an employee, it is your job to be aware of how you respond to and approach others. Is your behavior unwanted? Please ask yourself, would I want my behaviors to be the subject of public discussion or appear on the evening news? Is there equal power between me and the person that I'm interacting with? Has the person told me to stop the behavior? Do I want to be personally responsible for my behavior and face financial and legal consequences?
It is unlawful to harass a person, an applicant, or employee because of that person's sex. Harassment can include sexual harassment or unwelcome sexual advances, requests for sexual favors, and other verbal or physical harassment of a sexual nature. Harassment does not have to be of a sexual nature, however, and can include offensive remarks about a person's sex. For example, it is illegal to harass a woman by making offensive comments about women in general. Both victim and the harasser can be either a woman or man, and the victim and harasser can be the same sex. Although the law doesn't prohibit simple teasing, offhand comments, or isolated incidents that are not very serious, harassment is illegal when it is so frequent or severe that it creates a hostile or offensive work environment, or when it results in an adverse employment decision, such as the victim being fired or demoted. The harasser can be the victim's supervisor, a supervisor in another area, a co-worker, or someone who is not an employee of the employer, such as a client or customer. Sexual harassment is a form of employment discrimination prohibited under Title VII of the Civil Rights Act of 1964, and under the laws of many states. Examples of prohibited types of harassment and discrimination include age, derogatory comments about someone over or under a certain age; race or color, comments about the color of a person's skin, or the use of slang expressions to describe someone's race; national origin or ancestry, comments about an individual from another country, using ethnic slurs or telling ethnic jokes; disability, mental, physical, making reference to or labeling the handicapping condition or limiting the individual's activities on the job, such as talking softly to the hearing impaired, placing obstacles in the path of a blind person, putting items out of reach for someone in a wheelchair; sexual, comments, jokes, brushing against, blocking way, touching, asking out, printed material or dominant behavior; gender and gender stereotyping, harassment based on perceived differences from typical gender expectations.
Quid pro quo is Latin for this for that, or something for something. It refers to an exchange. In this case, the exchange is between a person in authority and his or her subordinates. One party is asked to provide sexual favors in exchange for something else, such as grades, favorable treatment in work assignments, recommendations, pay, or promotion. Examples would be, have sex with me and you will receive that raise, or, have sex with me or you won't get a raise. Quid pro quo occurs when employment decisions and conditions are based upon whether an employee is willing to grant sexual favors. It is usually more severe, and occurs less frequently than hostile work environment sexual harassment. Some of the working benefits that can be made conditional on sexual favors are hiring, promotions, salary increases, shift or work assignments, and performance expectations. For example, Marissa's boss asks her to work late with him to complete a project. While they are alone after hours, her boss repeatedly tries to rub his hand against her thigh and attempts to kiss her. She resists his advances and tells him she is not interested. The boss eventually stops the behavior and leaves, telling her to finish the project herself. Neither person mentions the incident again. However, the following week, Marissa's boss gives her an undeserved poor review and denies her an expected pay raise. Other examples of quid pro quo are, when Ryan refuses the advances of his department chair, she assigns someone else to the summer course he has been teaching for years. Or, the operations manager tells the summer intern that she will be hired on as a regular employee if she would agree to go out with him. Or, a week after Matt ends his relationship with Chad, who is also his supervisor, Chad tells Matt his position has been cut, and fires him. Or, when April requests time off from work, her supervisor tells her that she can earn time off by granting him sexual favors. In regards to quid pro quo, a person does not have to prove that they suffered an economic loss, such as being denied a promotion or a raise. To prove quid pro quo sexual harassment, it is enough to show a threat was made or reasonably implied. According to federal guidelines, a single sexual advance may constitute harassment if it is linked to the granting or denial of employment benefits.
A hostile work environment is one in which unwelcome conduct of a sexual nature creates an intimidating, offensive, or disruptive work environment for one or more members of the company. Examples of this conduct may include sexually explicit talk, text, or emails, sexually provocative images, comments on physical attributes, or inappropriate touching. Harassment can take many forms, including sexual harassment, threats of violence, name-calling, or other harassing conduct. Harassment creates a hostile, intimidating, or an offensive environment and can violate anti-discrimination protections. It is humiliating treatment likely to affect the health or safety of an individual. It is the impact and not the intent that matters. It almost always occurs in a matrix of power. The following example could be construed as hostile work environment sexual harassment. Jake and Erica are co-workers in adjacent cubicles. Jake frequently enters Erica's area, sits down, and begins describing details of his sex life. He also tries to encourage her to participate in the discussions. She tells him that she would rather not hear these stories, and he takes the opportunity to tell her that he could help her release all of her prudish sexual inhibitions. He will not stop these unwelcome conversations, regardless of how often Erica makes the request. She is hesitant to file a complaint because, other than this behavior, Jake is pleasant and helpful. Jake and Erica are co-workers, and Jake is not asking Erica to exchange sexual favors for better working conditions. His behavior could be considered hostile work environment sexual harassment. A hostile environment situation may also be created by conduct that is gender-specific, but not necessarily sexual in nature. When Haiti informs her supervisor she is pregnant, he becomes angry. He tells her that, if she cared at all about the department or her colleagues, she would just resign rather than disrupt everything by going on maternity leave. The supervisor often points out in meetings that Haiti won't be able to do certain projects because she will be on her little vacation. He takes assignments away from her, citing her inability to follow through because of her coming leave. As she progresses in her pregnancy, he mocks her by imitating how she walks and how she sits or rises from a chair. Heidi's work environment has become abusive based on her pregnancy, and both her work and her health are affected. The supervisor's behavior is unacceptable and very likely a case of hostile work environment sexual harassment. Here is another example. Dina works in the office of the maintenance department. She keeps her hair cut very short, dresses in men's clothing, and does not wear makeup or jewelry. Mr. Anderson, one of the managers in the department, calls her Dean. He frequently comments that she should dress in a more feminine manner and that the men prefer to have pretty girls in the office. Mr. Anderson has also called Dina a derogatory term for lesbian on several occasions. Although Mr. Anderson's comments are not sexual in nature, they may nonetheless constitute harassment on the basis of sex. His comments deride Dina for her failure to conform to stereotypes about how women should dress and appear. Discrimination on this basis is prohibited by federal and most state laws. A hostile environment can result from many different types of abusive acts, if they are based on any protected category. Here is another example. Paul is an employee with a disability who works for the housekeeping department. Some of the employees, and even some of his co-workers, think it is funny to tease him about his disability. They call him insulting names and interfere with his work by intentionally spilling liquids or emptying trash cans in areas Paul has just cleaned. These behaviors make Paul's environment abusive and hostile and are a violation of the law.